Yeah, you have your lordship's leave to mention a stay application, lordship. I filed it last week.
Yeah, I'm late. That's why so much of gathering from you.
Lordship, may I hand over the slip to your lordship's office?
What?
A stay application, lordship.
Connection with what?
Lordship, group 2 matter, lordship.
Yeah.
And lordship, a contempt application order of 29th March 2023. Lordship, for some reason, your lordship has directed the matter to come in the list, but it's not coming. I'm handing it over to you, lordship.
Yes, yes.
My lord, may I be permitted to mention one matter for correction? Your lordship were pleased.
Both of us?
Yes.
My lord. With your lordships kindly, my lord. An urgent order 41.
May your lordships kindly, my lord, to mention, my lord, one to be mentioned matter, my lord, to appear under the heading to be mentioned, my lord. I will be praying for that, putting my special messenger cost for pulling the lower court records.
My lord, with kind leave of Honorable Justice Bisha, I am mentioning one Andaman matter. My lord, sitting with Honorable Mr. Justice Rai Chattopadhyay has passed this order. It is arbitration about matter.
What?
The matter may be listed any date, my lord. Because last,
Sir, passed an order, then what?
but your lordship last order passed on 22nd March 2024, where the Honorable Apex Court case was pending. The opposite party has gone to the Honorable Apex Court. Now on 4th November, the Apex Court SLP has been dismissed. Order passed by the lordship has been affirmed. Therefore, by I am mentioning, my lord, I find one application for modification of this order, my lord.
Modification. Yeah, that's the modification.
Great.
May I have your lordship's kind leave, my lord, to mention, my lord, two identical appeals, my lord, in connection with an ex parte ad interim order of injunction, stay application, my lord. May I?
Order
Appellate
41.
side. My lord.
Order 41.
Yes, my lord.
Application.
Stay application, my lord. Well,
If it is admitted, stay application has no value.
No, it is not admitted yet. It's pre-admission.
That's why.
Yes, pre-admission.
So it has to be admitted first, then
Yes, my lord.
question of application will come.
Yes, my lord.
Right, order 41.
Order 41, my lord. Yes, I'll mention that and I'll hand up this.
Okay.
Oh, your lordship, your lordship.
Application. Without admission.
Oh, your lordship, may I be permitted to mention one matter under the heading application? The instant of
To or what?
FMAT, your lordship.
FMET means what?
Group.
Admission has been done.
Property matter. Your lordship, property matter.
So admission has been done.
Yes, lordship. An order of service for the order has been provided by this learned court.
Doctor, I'm sorry, Lordship, for embarrassing that this matter already heard by your lordship, and I have think for the judge.
Maybe you do it. We can't be because of the long vacation. But before that, my brother was not there. Gone to the Jalpaiguri. What can be done? এটা দেখে নাও, এটা রেডি হয়ে গেছে কিনা এটা দেখে নাও। এই আজকে দিয়েছো কিছু? আচ্ছা।
May I permit to mention a matter order 41 rule 11 group? Order 41.
My lord, may I have your lordship?
All order 41 rule 11.
My lord, may I have your lordship's kind leave to mention your lordship directed on 5th of August 2024 that Jalpaiguri matter, my lord, after it was assigned before your lordship, that it would appear in the list 2 weeks since, and along with certain other matters. No, my lord, there is a problem. My junior spoke to your lordship's learned officers. There is a problem that is a MAT 13 of 2019. Jalpaiguri matter. Now, when it is being tried to be tagged with other matters, there is another MAT 13, some other MAT 13 of 2019 over here. So, possibly, my lord, it needs an order of your lordship. So, if it comes up,
What order?
My lord, that's what I was told.
Detachment or what?
Renumbered. That it needs to be renumbered.
I do not know. এবার ফাইলটা আমাকে দিয়ে তো বার করতে। ফাইলটা আগে একবার দেখাও।
Lordship.
Keep you obliged, my lord.
May I be permitted, Lordship, mention one matter? Item number 51 of today's list. Lordship, matter has been against the judgment and degree of the city civil court matter has been appeal has been papered. If my lord takes up the matter or release the matter.
Release
51. Item number 50.
51. Taken out of turn on mentioning, released on my ground. Yes.
May I see your lordship's indulgence, my lord? But it's a long pending matter. Item 88, my lord. Upon notice, my lord, I'm appearing.
Where yesterday, where you were day before yesterday. where you were on last Friday, where you were. We have to rise early.
I was waiting
you
before vacation. I mentioned on several occasions.
After vacation, we
I didn't mention.
rise the whole list. Nobody was there. We waited. Anybody, where both sides, we are ready to take up. Nobody. Upgradation. No.
But may I just
We will call.
because your lordships has already gone into the matter.
I have gone. I think we have gone in all of the matters.
May I come back in the next week?
No, let us see. Just watch the list and respond when it is called.
My lord, may I mention one order 41 rule 11 matter?
Yes, call the list.
But I appear for the petitioner as an application for restoration.
Really? Yes.
My lord, I beg to appear on behalf of the appellant.
Was the provision of law. The single judge was also grappling with this situation. So please show us the relevant rules. Who appeared before the single bench?
My lord, learned advocate on record, madam.
Where is he?
My lord.
Savita Kutia, where is he? I could not find.
She's in trouble, my lord, on traffic jam, my lord. My lord.
He has discontinued the interest on gratuity delayed payment matters. Or is still filing it. Savita Kutia, প্রত্যেকদিন 50টা মামলা করতো ডিলেড পেমেন্ট অফ রিটায়ার বেনিফিটস ইন্টারেস্ট দেবে 50টা।
My lord. Paragraph 23(2). Paragraph 2.
See?
23(2), my lord, paragraph of DCRB scheme 1981. Notification dated 136B 15.
No.
Yes, my lord. Gratuity.
Will not do.
Yes, amendment. I am showing, my lord. Kindly give me time. That has been amended. Gratuity.
He was getting a pension.
No, my lord. Then, my lord. Next, my lord.
But one
Memorandum number 340, by which that gratuity.
You are referring rule 20.
Well, my husband received gratuity.
Have patience.
My lord. Sir.
Have patience.
My lord.
When we have a patience to hear you, you must have also patience to hear us. You are referring 23(2). I am talking about why not 23(1).
23(2), my lord.
I am talking about why not 23(1).
My lord, while
no.
he
was not retired. Did not.
After retirement,
Yes.
he died.
2.
Then, my lord, that my lord
0
340, my lord, I page, my lord, 550. 550. 550.
Yes.
My lord.
This is a 340 memorandum.
My lord.
3rd July 2008. When you died. I mean, sorry. When your
husband died in the year 2005. My lord.
So this is the same thing, why it has,
My lord, my lord. Then kindly take the trouble.
he was getting a pension or a
Yes, yes,
compensation, then a family
yes, my
pension.
lord. Yes, by which, my lord, this memorandum is not applicable to me because of the fact that my husband, my lord, retired prior to issue of notification amendment of the paragraph 23, subparagraph 2. By
Then
member,
what was unamended paragraph?
yes,
Where is an unamended paragraph?
unamended paragraph 23, subparagraph 2, my lord.
No, this is an amended paragraph.
No,
Where is an unamended?
23 2, my lord. My husband received gratuity. Here, my lord, the word gratuity is there. By amendment, gratuity is deleted.
No. No.
Yes. Yes, my lord. The benefit shall also be admissible in case of death of an employee after
No,
retirement.
This was 2008 amendment.
Yes, my lord.
This is of 3rd July. But you are referring where the gratuity is still appearing into at page 419. Please come. This is an amended 23-2.
340, memorandum 340,
Probably you are not getting, sir.
my lord.
Please, I am requesting you.
My lord.
Please listen.
My lord.
Come to 419. Page 419.
419.
Read, please.
The
Please,
benefit.
first thing, asterisk is there.
Yes, my lord.
Asterisk at the bottom you will find
Yes.
the para 2 of para 23 to be modified by circular dated 3/7. So that
340.
means it is a modified circular or unmodified?
Modified circular.
Is it modified one?
It is
or
unmodified.
unmodified
It is,
one?
my lord, modified by this paragraph.
So this is unmodified.
Unmodified.
So gratuity is there
Eh.
by 340 is memorandum.
Gratuity deleted.
Is excluded.
Excluded.
So if you come prior to this, prospective effect cannot be given.
Yes, my lord.
This is what you
Yes,
want
my
to say.
yes, my lord. And government
Here-
and government issued notification to that effect, my lord.
There.
Kindly, my lord, paragraph 66 of my stay application. Kindly take up. Kindly take the trouble.
That was before July, sir.
My lord.
That was before July.
Memorandum number 352F.
Yes.
Pension 26th May 2008.
Yes.
My lord. Kindly refer to you such and such memorandum seeking clarification as regards the date of effect of notification 674F 37 2007. The matter referred to us has been examined, my lord.
26 May. When you had 30th July 2007 notification.
Yes, my lord. Page 65.
সেকেন্ডারি না না এখন ভাত থেকে তো নিয়ে আসবো সেকেন্ডারি বইটা সেকেন্ডারিটা নিয়ে আসবো ঠিক আছে।
Yes, I got it. Yes, Mr. What do you mean? These notifications are issued by you. He died when the original this DRB rules that was there, which contains that if anybody who retired, having not completed the
10 years
10 years of quota, but if he received gratuity, invalid, retiring or superannuation pension, if he was getting a compensation, then his family would be entitled to a family pension.
Yes.
Correct.
Under
That
paragraph 20.
the gratuity part was deleted at page 65. If you come by 30th of July 2007, this was deleted.
Yes.
Then 66, there was another notification on 26 May 2008, which says that no, if he received a gratuity, then he is entitled, the family is entitled to family. Then the gratuity part was deleted by a July notification of 2008.
Yeah.
Now it cannot be given a retrospective effect because the right to receive pension accrues the moment the deceased employee's family come within the purview thereof. He admittedly died prior to 2008 amendment. Then, by virtue of this
Retired
on
Miller,
26
retired Miller.
On a kind
Died up
he
thereafter.
also
from first pay night.
died also before 26 when?
My lord, he died after 13/12/2011.
Oh,
Died, but he retired before.
retired will not do.
No.
No, my lord. My lord,
I was under the impression that he
no, my lord,
died
my lord,
prior
my
to
lord,
2008.
my lord, my lord, my lord. Excuse me,
then
my
it
lord,
is
my lord, I beg apology, my lord.
Sorry.
Here, my lord, here,
That's
my
why
lord,
I said,
kindly, my lord.
listen
May I?
and patience.
May I, my lord? Here, my lord,
He was
retired prior to.
Just
My lord,
one second.
retired,
Just
retired
one
prior
second,
to,
one
please,
second.
please.
One second.
Retired prior to 37/2007.
30th April 2005.
My lord, not died. Retired prior to. My lord, kindly see again, my lord, if you lordship. Kindly see page 66, my lord. The notification dated 26th May 2008. Kindly, my lord. Retired prior to 37/2007. Received gratuity, one criteria. Second criteria, if he retired prior to 37/2007. He retired prior to 37/2007. No criteria of death is
Yes.
here, my lord.
Kindly see the language, page 66. Kindly refer to your letter DO number such and such, dated 17th of October, seeking clarification as regards the date of effect of the notification number 674 FPN dated 30th July. The matter refers to have been examined and now it's clarified. The notification on the reference will take effect from the date of issuance, that is 30th July 2007. The specific employee who received gratuity as retirement benefit and retired prior to
What he
30th
says
July.
is that the retirement must be prior to 2008 circular, and if it appears at the time of his retirement, he has received a gratuity, because the word is if he was in receipt, he is not. He was in receipt of a compensation, invalid or whatever, and or gratuity. Then on his death, the family is entitled to a family pension. So if he received a gratuity, that is his case, he received gratuity. So in that event, even if he died in 2011, but at the time of retirement, he received the gratuity, so he is entitled to a family. That's
One kindly see. One are checking. Paragraph 23.
এটা বার করো
পেনশন
পেনশন গেছে ক্লারিফিকেশন
1435 1435 বার করো
We are passing in direction. Six. What is this application, sir?
This matter was heard by Your Lordship on earlier occasion on 2 occasions. My learned friend has now come up with a affidavit that in the DLIT report my name was not there.
Oh.
Now, my submission before Your Lordship, this issue is a dead issue now. In view of Supreme Court judgment and the order of the Secretary, it is a dead issue. So, this is not a relevant point taken before this division bench. This is my submission. Though we are filing affidavit saying that headmaster and secretary, we are compelled.
They have used this affidavit.
Yeah, secretary and headmaster, we are compelled to delete our names only because to have the upgradation completed, so that 9 and 10
Have you
students
served the
can come.
copy?
Yes, sir.
Yes, sir. Twice. Yes, sir. Twice.
Yes, sir.
What?
Pakistan yesterday also.
Yesterday also, sir.
Yes, Mr. Mukherjee. Yes.
My client also filed a supplemented.
এটা ওদের বই ছিল এখানে আছে What is the matter about, sir? Can you just
Yes, I am giving.
history of the litigation?
Yes. My lord, only. Yes, I am giving it kindly. My lord, the school was junior high school was established prior to 1975. A junior high school established prior to 1975. This school applied for special permission for sending the class 9 students and class 10 students to appear in the Madhyamik examination that was allowed by the DI and the board.
And
That was allowed by the board
board
to appear in
DI
the
and board.
Yes. Now they applied for the upgradation for
Yes, I submit.
that upgradation was allowed. That upgradation, we applied for the upgradation on 6th July 1975, and upgradation was allowed on 1st May 1999.
Correct.
Then before that, we are sending the students 9 and 10 for appearing in the Madhyamik examination. We appointed teachers to teach the 9 and 10 students in the relevant subjects. I was appointed as a PU science teacher having degree BSc honors B.Ed. I was appointed on 2nd March 1996 and I joined on 11 March 1996. One inspection was held on 12th of February 2096.
2000?
My name was not there.
2006.
1996. My name was not incorporated, I do not know. Then on 12th of June 1998, a surprise visit was made by the DI, whether actually I was working on my representation, he came. Surprise visit. Then he found me that I am working in the school. Then school was upgraded on 8th September 1999, completed. I moved a writ petition. I and others moved a writ petition before this honorable court for our permanent service. And Justice Ansari passed an order upon the DSE to consider the same and to maintain the status quo of the teachers till this is decided by the DSE. DSE passed an order on 2nd December 2023. 2003, sorry, 2003, that two persons that one group D amongst us, one group D will be absorbed and one teacher will be absorbed.
Not you.
We are excluded.
In language group.
We are excluded. Then
Not we, you are excluded.
I am because I was the writ petition was made by 4 or 5 persons.
Here
I was
Mr.
excluded. Then thereafter, my lord, nothing was. I moved another writ petition before this honorable court. This honorable court passed an order that I should be absorbed with retrospective effect. State government preferred appeal. Appeal court relying upon Uma Devi 3 dismissed.
Dismiss means
I-
set aside. Set aside the order. So no absorption.
Uma Devi 3.
There is no absorption. Then
No objection.
No objection. Nothing. Then, my lord, we moved the Honorable Supreme Court. Honorable Supreme Court passed order on certain, giving certain directions, holding something. I will place the Supreme Court judgment. Then Supreme Court lastly passed an order considering some merits of the case upon the Secretary of the Education Department to pass an order so that a sympathetic view can be taken for the absorption of these particular teachers because they are working from 1996. Long years they have served in the school, and Supreme Court ensured that school should ensure, Supreme Court says school should ensure that we are working in the school, that should be placed before the secretary. School authority appeared and stated that we are still working. In the meantime, still working. Then I moved the writ petition. I challenge, secretary rejected our application. I moved the writ petition. That writ petition has been rejected by trial court. Against this order, we have come before your lordship. Now, in the meantime, on 31st of October, I have attained the age of retirement. And the school authority is still taking my service in the school as because there is no teacher to teach pure science in the school in class 9 and 10, which is compulsory subject. Still, I am working about after retirement. This is the need to meet the public need, student need.
that is arrangement between you and the school authorities after you attained that.
That is, I felt that
Government cannot say anything on
No.
that.
I felt that and school is taking my service. I felt that I should also give service. Since there is no teacher, the students should not suffer.
That is after retirement. Only thing is up to the stage of
Up to
retirement, you're right.
31st of October 2024, my
24.
service was there. Now, your lordship kindly consider, earlier the judgment of the Honorable Supreme Court.
Where is that, sir?
Now, your lordship kindly see the judgment of the Honorable Supreme Court. Page 126.
On 20.
আরে ভাই এরকম করলে কি করবো? Kindly see page 126, it begins. And relevant portion, our case starts from page 127, bottom. We have heard Mr. Bhaskar Prasad Gupta. I not got it.
No.
127 bottom. তোমার সঙ্গে মিলছে না না 127 তো 127
147. Please consider page. Page is not telling. 127. Said 147, so I just.
Most probably 127.
Yes.
We have heard Mr. Bhaskar Prasad Gupta, learned senior counsel appearing for the appellants, Mr. Kullan Bandopadhyay, learned senior counsel appearing for the state of West Bengal. As it appears to us, the grievances of the appellants in this matter challenging the order so passed by the High Court without regularizing the appellants on the ground that cases of the applicants were hit by the judgment in Secretary State of Karnataka versus Uma Devi and others reported in 2006, volume 6, volume 4, page 1. However, now this is starts. However, we have heard learned counsel on the facts of the case in question. Very important. On the facts of the case in question. It appears that the appointments which have been made by the managing committee in the matter in respect of the school in question and who had worked for such a long time in the school, their appointments have not been regularized. It appears to us that West Bengal School Service Commission Act 1997 came into force in the matter after recognition of the school. After recognition of the school, kindly consider, Bharat. It was a case of the state that no teacher can be appointed except in accordance with the provisions of the Act. However, we have specifically gone through the facts of this case as it appears to us that school was originally a junior high school recognized with effect from 1969. Thereafter, the said school was upgraded to class 9 high school with effect from 1/5/1999 and thereafter to class 10 from 1/5/2000. Admittedly, this is I am giving emphasis. Admittedly, the appellant joined the school before the upgradation. Recognition as class 9, class 10 high school, classes 9 and 10.
Here, Mr. Bhatt, just to give you some kind of a relaxation, I have already read the whole of the judgment. The judgment goes on that because the state was of the view that after this School Service Commission Act has introduced in 1997, the appointments cannot be made by a managing committee of the school. It should be made by the whatever under that. So these appointments were not considered to be a valid appointments according to their submissions. The court says that there was a judgment of Uma Devi. We are conscious of that situation since you were serving for a long time and you claim that you were uninterruptedly and continuously serving there. Direction was passed upon the authority, state authority, to go and find whether you are really serving. In the event, if it is found that you are serving, then an opportunity of hearing must be given to you. And the court and the authority will consider the case uninfluenced by observation of the High Court, but in accordance with law, and will take a sympathetic decision because you are still or already working in the school. So nothing apart from that was said by the Supreme Court. Ball was rolled into the court of the authority or in the domain of the authority.
Now, my lord, can you see what is the authority said? Next page 130. It appears that grievance of the petitioner, my lord, I am not reading. This is
No, it's not, I think paragraph 9 is relevant, having considered the fact. He has simply quoted it.
only
He has admitted that
only
three persons are
only
still
now,
working.
no, only 8, paragraph 8, because now he has,
Found that 3 persons are working, including you.
yes,
No
now
difficulty.
he has filed this particular reality report to mislead the court. To meet this point, I am referring to paragraph 8.
Paragraph 8 recognizes that you are still working. No
So
difficulty.
this particular reality report does not come into picture now.
Whatever.
Now 9, having considered facts and circumstances of the case, already facts decided and were taken into consideration of the section 2N and section 2P of section and section 10 of West Bengal School Service Commission Act 1997, it is found that petitioners cannot claim the coverage of protection of section 10. Section 10 of the West Bengal School Service Commission Act, since they are not teachers to the sense of term teacher as modified in section 2 of the West Bengal School Service Commission Act, with reference to school service such and such or West Bengal such and such, school authority allowed them to work in the school, devote the rules and regulations only in the anticipation that they would be recruited as and when school would be upgraded and government would sanction requisite posts to absorb them. But as for Rule 28 of the management of the recognized non-government institutions framed under the West Bengal Board of Secondary Education Act 1963, the managing committee of the school was vested with the power subject to the provisions of any grant in a scheme and pay revision scheme or any order, direction or guidelines issued by the state government or director and enforced for the time being to appoint teachers and other employees on permanent basis against permanent vacancies, if available, within the sanctioned strength of teachers and other employees, and approval of such appointment should be thereafter sought for from the director or any other officer authorized by him with a specific period. Similarly, such managing committee had also power to appoint teachers and other employees on temporary basis against permanent or temporary vacancy within the sanctioned strength of teachers and other employees of the similar manner, but in the said rules. No power has been given to the managing committee of the school to appoint any teacher or non-teaching staff beyond the sanctioned strength.
What is the only, this,
No, my lord.
any appointment made by the managing committee beyond the sanctioned strength, that appointment cannot be accepted in view of the definition of a teacher, in view of the provisions of the School Service
Section
Commission Act,
10,
and the management rules also has been considered.
Section 10 of the West Bengal School Service Commission Act came after our appointment. After it does not apply to us.
But the Supreme Court says your case would be considered in the light of the provisions contained in the West Bengal School Service Commission Act.
Supreme Court said, kindly consider, Supreme Court said that in view of that, it appears to other appellants since working for such a long time in the said school, their cases should be considered.
No, you are reading, but you are not reading the earlier sentence.
The earlier sentence you will also
There is a direction passed by the Supreme Court to consider.
This is the finding of the Honorable Supreme Court.
That is what I am saying.
Supreme Court said
Mr.
That we
Judge,
should be
what
considered.
we learned from you,
Considered meaning.
what we learned from you, what we learned, you have also taught us.
Consider has a definite
Want
meaning.
to read a judgment, you
What
must read the judgment as a whole. You cannot divorce one sentence or one line from there. What was the spirit of the judgment of the Supreme Court?
What
It was very clear.
What considered as a definite meaning? Your Lordship knows the 2 or 3 decisions from 1968 onwards. What is the meaning of considered? Considered
Application of mind,
application of
assimilation
mind and facts and also to consider the merit also. Now Supreme Court said no, Supreme Court said the Service Commission Act came later on.
Which page 128?
128. Supreme Court said that Commission Act having come into force after the issue reached the finality, whether that will be applicable, Supreme Court does not say so. In similar cases, our High Court passed order for absorption. Niranjan Shah, where Supreme Court, Your Lordship already considered on the last occasion, Niranjan Shah, our division bench also in the same circumstances considered the issue and passed the order of absorption. Kindly see this, our division bench is already before Your Lordship only considered on the last occasion.
No,
Now, kindly see, because all the judgments have been considered, they are in this case, this is not necessary. Oh, my land friend appeared there. I have given the copy. He appeared. Now, my lord, our division, I direct the appointment. Kindly see, my lord, internal page 13. Kindly see, Supreme Court, our High Court is issuing mandamus desperately, courageously. Mandamus is a matter of courage and desperateness because it can be issued to do justice when the situation arises and injustice being done. It is a plenary jurisdiction of the Honorable High Court. This is not the adversarial jurisdiction like civil court.
Supreme Court Supreme Court
Now, my lord, can you see the judgment? Page 13 bottom. I direct the respondent board to regularize the appointment of the appellants by appointing them as assistant teachers of the said school from the date of recognition of the school. Since the said financial burden on the state would be very high, there shall not be paid actual salary from the date. Their salary from that date shall be calculated notionally, taking into account normal increment. The appellant number 1, who has retired, shall be entitled to, my lord, I am giving emphasis on the same. Now, my lord, can you see what our division bench said? The division bench said, because these facts fit with my case. Appellant number 1, who has retired shall be entitled to arrear and current pension based on his notional salary on the date of his retirement. The appellant number 2 shall be entitled to join such and such. Now, these was have the journey to the Honorable Supreme Court. Supreme Court also said, this petition call for hearing, delay condone. In the facts or circumstances, we are not inclined to entertain the present petition. Special leave petitioners are dismissed. You also got the order. We have handed over the Supreme Court order earlier before Your Lordship. Got the order.
Point kept open.
Oh, that is all. Law point can be, which we have not argued before Your Lordship. We can argue before the Supreme Court also. Your Lordship knows this judgment, paragraph 10 of 2009, volume 10 Supreme Court cases. Point of law can be argued before the Supreme Court for the first time also. 2009. So this is the old. Yes. Oh, another thing was added by the Supreme Court. If it is argued, the point is argued, though it is not in the pleadings, but if it is argued between the two parties in the before the court, on that issue also he can raise the new point, question of law before the Honorable Supreme Court. Argued, but no decision was given. That can be argued before the Supreme Court again. So, my lord. So, my lord, now we have come before Your Lordship. In another decision also was passed by our division man, another division, another judgment also passed by the division bench. Division bench. Due to the subject,
এই দুটো দিতে বলছে এটা তো
division দুটো
No, no, no. Yeah, that has been clarified by Justice Dipankar Datta, which has been
the judgment has no issue. This is not applicable at all in this particular case. I have seen the Justice Datta judgment. It is non-issue. Non-issue.
Kindly see the date of recognition of the institution, 2009, when 2005 Act,
This
97
is not the case now in view of Supreme Court and the Secretary's order. Secretary did not deal with this particular point, which now raised by my learned friend. He also knows the Supreme Court judgment say 2014 volume 4. What is the duty of the government lawyer? Government lawyer should assist the court on the facts which are admitted. Now in 2014, I can show you Lordship before you Lordship. Now government lawyer stating many things before the court in many courts.
Then we are
The Supreme Court
then
said
we are leaving the court.
this particular government lawyer, Supreme Court said that what should be the
Could not make any argument.
what should be the argument of the Supreme government lawyer? Kindly see.
According to Mr. Bhattacharya, we should not utter a single sentence.
No, no, this is not
should
Supreme
not
Court.
have
What
statement.
Supreme Court said.
But we are assisting the court.
No, you are not assisting.
না দাঁড়া না
Yes.
He is not assisting. Because after the division, after the Supreme
If
Court
I'm
judgment-
incompetent to assist, according to Mr. Bhattacharya, I'm incompetent, then can his lordship pass any order out not? No, he is a boss. He's respecting to a member of senior council. But he has said that he is disrespecting me. Have I suppressed any fact? Have I suppressed any fact? That has been placed before the learned single judge. Yes.
Yes. Well, may I read the judgment? If you say I get
Academic.
paragraph 33. Paragraph 33. I am reading. Yes. As far as the counsel for the state is concerned, it can be decidedly stated he has a higher responsibility. A counsel who represents the state is required to state the facts in a correct and honest manner. He has to discharge his duty with immense responsibility, and each of his action has to be sensible. The issue I am taking sensible. It is expected to have higher standard of conduct. He has a special duty towards the court in rendering assistance. It is because he has access to public records and is also obliged to protect the public interest. That apart, he has a moral responsibility to the court. When these values corrode, one can say things fall apart. Corrosion. We should always remind himself that an advocate, while not being insensible to ambition and achievement, should feel the sense of ethicality and nobility of the legal profession in his bones. We hope there should be opposite response towards duty, the hallowed and honored duty. This is the Supreme Court. Your Lordship knows this judgment. So, on my submission before Your Lordship, what the state. Yes. Your Lordship can see herein. Nobility and ethicality. Now, my submission. Yes. No, my submission in this case before Your Lordship, the Supreme Court said, another judgment, Oshit Bishas, I've given the copy, but
Oshit Gayan.
Huh?
Oshit Gayan.
Oshit Gayan. এটা অসিত তপন
ওটা তো শাহু।
অসিত গাইনের কপি দাও ওকে, ও নাহলে বলবে কি করে, ও পড়বে কি করে, আছে কি? হ্যাঁ,
না অসিত গায়ান উনি ছিলেন।
another I have given another copy, another judgment of say self-same division bench, self-same division bench. Self-same division bench, Oshit Shah, Oshit Ranjan Gayan. Our High Court again said vociferously when the education is the need of the hour and where there is the dearth of schools in the same area, page 13, resulting children to go for far off places such and to forego education up to certain period. So, my lord, My submission before your lordship. I will not take a lordship time. Only 5 minutes I will conclude my submissions. Lordship considers. My lord, two judgments I have shown before your lordship. Our division bench said they should be absorbed. Supreme Court said when in similar circumstances, the order has been passed by the court. That order should be applied in respect of others also. This is a judgment. Copy কোথায়? This is a judgment 2020 volume 18 Supreme Court cases page 733. Paragraph 7
2018.
and 9.
18,
And here in Supreme Court said
733.
with all back wages. Copy কোথায়? Delivered by Nagaratna. Judge. I mean, 2000. I have brought 2000.
2024 judge.
Oh, 2024. But I have brought one judgment of 2022. Oh, Nagaratna. Lordship name your lordship remember the names also parties I can find here today. Last week. Oh, I do not handle the mobile. I do not know nothing. Such it is difficult. My daughter lives somewhere else. I'm here, so I cannot get there. I take it. I cannot use a mobile and laptop. Not so. Now, my lord. I'm formulating the point. Yes. কোথায় গেল? Jasmine জোগাড় করলাম কোথায় গেল? 2000
20টা তো জেরক্স করতে পাঠালাম।
হ্যাঁ
20টাই জেরক্স করতে পাঠালাম।
20 volume 18.
হ্যাঁ, ওটা এক কপি আছে মাত্র। Just gone for the Xerox. Suddenly we lost the other two. Volumetry.
2020
আছে, দেওয়া আছে।
was lordship
Or a single case.
only consider the judgment. হ্যাঁ
7, 8.
and
2018 paragraph 7 or 8.
7 and 8. Another judgment on my lord 2022. I think I have given the copy 2022 volume 12. No, this is a new judgment. I'm giving the copy. I'm giving the copy. Paragraph 18 to 22. 2022 volume 12 Supreme Court cases 228. Paragraph 18 to 22. My lord, in this case, my lord, I am trying to submit before your lordship the order of appointment, my appointment, which was placed before the authority concerned for consideration. That order was not revoked at any point of time. Paragraph 13. My lord, the secretary passed order relying on section 10 of the West Bengal School Service Commission. What is the scope of the section 10 of the School Service Commission? You lordship kindly consider. Kindly consider. Scope of the School Service Commission. Service Commission আমার কাছে ছিল এখানেও ছিল School Service Commission আমার কাছে ছিল একটা My lord, kindly see section 10, how it applies. The voter whether the order of the secretary can be sustained. If it is secretary pass the I am referring to your lordship, secretary pass the order relying upon section 10 of the West Bengal School Service Commission Act. Whether section 10 of the School Service Commission has any manner of application so far in this case in view of the Supreme Court judgment. Supreme Court also take notice.
Section 10 কি বলছে?
Section 10, kindly see, does not apply at all. Section 10 said protection of teachers and non-teaching staff. This,
Yes. 10C was challenged.
protection of teacher. Yes. No, my submission before your lordship said,
Section 10 টা পড়তে বলছে।
my lord, notwithstanding anything contained elsewhere in these acts, terms and conditions of service of teachers and non-teaching staff in the employment of the school immediately before the commencement of the school shall not be varied to the disadvantage. This is the only point. No, because we are serving, I am serving in the school from 1996. We, according to the strength of sanction strength of the school in the subject in question, relevant subject in question. So the protection, I am entitled to the protection. I cannot be deprived of the said protection. I'm a teacher in the school. And this Supreme Court said, admittedly, you are working in the school. They said, state government said before the court, we are admittedly working in the school. So whether on a particular non-issue we can be this, Your Lordship. And the only one submission, this particular
I may be permitted to place certain documents on the stay application. On page 75, memo dated order dated 8 September 99, upgrading the school as a 10 class high school. Very important is the date of recognition, upgradation of the schools. 8 September 99. 2009. 99. Last paragraph. Yes, I'm directed to inform the president of the board in exercise the power vested him under section 22 of the West Bengal Board of Secondary Education Act as amended has been pleased to consider the report and the recommendation of the state government conveyed under the Education Department letter number such dated 8 September 99 to upgrade a school as a 4-class junior high school. The 1st May 99 and from 1st May 2000 provisionally for 3 years subject to the fulfillment of normal conditions enclosed, the school will send up first batch candidates at the Madhyamik Pariksha Secondary Education 2001. The school is allowed to admit class 8 pass students of the recognized 4-class junior high school or recognized high schools on the basis of the valid transfer certificate and should not get these admitted students 9 and 10 from 1st May. Yes. 99 and 1st May 2010. Yes. This is then what are the conditions mentioned here? Next page, page 77. No, kindly see the last page 76. Yes. Kindly see it. Clause 6. Page 77. Yes. Paragraph 6. Yes. Then, kindly see paragraph 15. The appointment should be submitted to the board to the effect that the go to that West Bengal and issued by the West Bengal Board of Secondary Education from time to time. When this memo was issued, 8 September 1999. The West Bengal School Service Commission came into force 97, 1st November 1997. School Service School Service Commission Act and provides that no teacher should be appointed unless he is recommended by the School Service Commission. Then on the date of upgradation of schools, West Bengal School Service Commission was there. Then protection, those who are given section 10, kindly for a moment. Notwithstanding anything contained in any elsewhere in this act, the terms and conditions of the teachers and non-teaching staff in the employment of school immediately before the commencement of the act shall not be varied to the disadvantages of such teachers and non-teaching staff in so far as terms and conditions referred to the appointment teachers, non-teaching staff, the post held by them immediately before the council. This section 10 has been dealt with. Kindly see the definition of teachers. 2P, section 2P. Teacher means an assistant teacher or any other person holding a teaching post of a school recognized by the board or the council as the case may be, and includes headmaster or headmistress, but shall not include assistant headmaster or assistant headmistress teaching holding post against short-term vacancy caused by. That means when a teacher means the school has been recognized by the government or board. Right. About this act. Yes, I'm grateful to it. Well, this section 10 has been dealt with by a division bench of our High Court, 2008 1 CHN 582 days. Due to this. Correct to this? Well, similar questions came up for consideration before a division bench. They were organizer teachers, they paid for approval of their appointment, and it was contended by the appellant that their service is protected under section 10. Kindly see paragraph 22 for a moment. It is submitted by Mr. Dey, learned advocate, that the School Service Commission Act came into force 1st November 97. Have you also got it? And admitted the present petitioner responded to an appointed a teacher prior to the coming force of the said act. According to the School Service Commission does not have any manner of application in the present case. The service of the petitioners were protected under section 10 of the West Bengal School Service Commission Act. But we are of the view that section 10 of the West Bengal School Service Commission Act has no manner of application in the present case. Section 10 has applicability of these. Yes. 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 But this, then Malad kindly see, Malad in the meantime, Devi Prasad Sengupta, Justice Pranab Kumar Dev. According, but Niranjan, Justice Data, Dr. Niranjan Chowdhury, yes, page 7, paragraph 6. Page 6. And this has also, yes. And judgment of Justice Bhaskar Bhattacharya, jo Moninu আছে না, murdered. But in my experience, sir, cases are different. We are dealing with murder. Yes. Yes. On a particular facts. Murdered. Yes. 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 Yes, yeah, kindly see, what are- what is the date of the recognition of the schools? And kindly see, their lordship has not been dealt with, or no occasion to consider the dealt with. What is the date of recognition of the schools or upgradation of the schools? I will go there. Kindly see the another judgment of Manindranath Sinha went up to the Manindranath Sinha went up to the Supreme Court. But another division bench, presided by Justice Dipankar Datta, court number 3. Court room number, no, Justice Datta, as his lordship then. As his, sorry, as his lordship then was, then held that this Manindranath Sinha is a judgment under Article 141. এটা দাও তো আব্দুল বাড়িটা দাও তো kindly see the Abdul Bari's judgment, Justice Dipong, Division Bench by Justice Datta. No, no, আমার খুঁজে পারতো kindly see already have handed over to all of you. Manindranath. Yes. On the first thing, that was case of 1994. And this case, the upgradation made in 99, when the act came into force. There are two different things. No, when it was already junior high school plus 8, then upgradation. Monada. Up to class 8. No, not taken over. Only upgradation. Organization. It's still going on, still going on. No, Monindo not seen, I guess. Monindo seen it. Monindo seen it.
The Supreme Court.
No.
Division.
When kindly see Monindo not seen,
Yes.
paragraph 16. Paragraph 15 first. First, on a power of the committee, paragraph 14. In a dated institution, the committee shall subject to the provisions of the granting scheme or pay division scheme or any order or directions or guidelines issued by the state government or the director in connection therewith and force in timely force have the power to appoint teachers and other employees on permanent basis against permanent vacancies within the sanctioned staying of such teachers and other employees. Approval of such labor being thereafter sought from the director or authorized by him orderly with a period fortnight from the date. To appoint yes. Kindly see paragraph. Kindly see paragraph 16. In our view, the present act, namely the West Bengal Board of Secondary Education Act, 1963 rules framed under to achieve the object of the said act, there is no provision for appointment of any organizing managing committee. Paragraph 16. There is no concept of organized teacher in the act, present statute. Board of Secondary Education Act. Yes. Organized teacher. There is no concept. Yes. Get food. Yeah. Model. No. Yes, great photograph. If the initial appointment is but the school was recognized as a fourth class junior school. Doctor?
Been appointed on 2nd March 1996. 6. Page 80. Page 80.
First November 97. 97. Rules. The DLIT report. Yeah. When the government has no power without the prior approval of the government. Can you see that? I mean, quote. But that has been quoted. Rule 20. But can you see that one is not enough? Paragraph 14. This rule has been quoted. Part of the committee. Have you not got it? Paragraph 14, middle portion. Part of the committee. In an aided institution, the committee shall, subject to the provisions of grant debt scheme or pay revision scheme or any order or a direction guideline issued by the state government or the director in connection with their rule enforced for the training forward to appoint teachers, employees on permanent again permanent vacancies. If available within the sanctioned state, the other employee, the approval of such thereafter sought from the director and other officer authorized to give a order. According to the same provision, the school was restored the power subject to the function against the pay scheme or any other direction by the state government or director in force, timing, and other employees on permanent basis. Again, permanent basis within the sanctioned strength of the teacher. And other employees and approval of such should be therefore sought from the director. Similarly, the Managing Committee has also power to appoint teacher or temporary basis against permanent temporary basis. Yes. Then means permanent basis against permanent vacancy. Got it? Against permanent vacancy available. Permanent vacancy 9 and 10 was there in 96. Granting its came, Malabar is key that all the salaries to the teaching are not. Yes, up to class 8. Class 8. The teachers are getting salary, employees are getting salary up to class 8. For 9 and 10, this matter has been referred to the school service commission. When the school was recognized as a 4th class high school, there was a valid managing committee. Has the managing committee has got any power to appoint any without the prior approval of the state government? The answer is no. Rule 28. Let him show a single paper in the paper or in the disclosed in the transport that prior approval was sought for, that was denied, or prior approval was granted. Assuming for a moment they were appointed in 1980. For which class? 9 and 10. 9 and 10 was not born according to the government record. That was forfeited from 1st May 99 and 1st May 2000. How? Before recognition to the school as a 9 and 10 class high school, how there could be an appointment?
May I make one submission?
Then but then they should have challenged the circular of the board. What are the conditions? Condition they have accepted. Page 77. The appointment of the teacher for class 9 and 10 should be made according to the staff pattern prescribed by the Director of School Education was sprung out. And paragraph 15 said that abide by the rules and regulation of the state government. Regulations means Act. 97 Act is there. 97 Act. Without the recommendation of the School Service Commission, no one could be appointed. Then your lordship will kindly see a judgment of the division bench of Justice Dipankar Datta as his lordship then was. I have placed before the lordship. Paragraph 19. Mat number 1626. Have lordship got it? DIR Schools versus Abdul Barik Sheikh, which has been relied on by the land signature.
একটা কপি দিলাম আপনাকে ওখানে যশোর কাগজে দেওয়া আছে এই যে আব্দুল
Paragraph 19 আছে already a 100 about you. I'm not finding out.
earlier occasion
Earlier occasion.
দেখেন না এটা দিয়ে দিন এটা দিয়ে
I'm supplying another one. is 2018 SSC online. Paragraph 19. Your Lordship got it? Applying the law laid down here, we hold that the monument having apart by the Supreme Court or benches of this court, in case involving matters similar to such situation, are bound to follow the same as binding precedent, and any decisions of a learned single judges which runs counter to the dicta of Monument Sinha, Titikona Maiti, Gita Bonik, and Gopal Singh is not good law. If this is a decision by the division bench of our High Court, but it was cited before the alternate single judge. On a Kakali, Justice Mukherjee judgment deals with the respect of the schools recognized in 1994. Yeah, but a very crucial date is date of application recognition by the board in 1999. Just give me 1 second, Malak. 1 second, Malak. ये तो देखो ना पता है क्या ये आईपीएम को दिया जजमेंट था कैसे on 16 November, the appellant was exercising power under section 20 of the Western Board of Jurisdiction, recognized school as a high school with permission to 9 from 1st May 2000, which was communicated to the Secretary Board by convention dated 1st May 2000. After this, then Malat, your lordship will kindly see. Malat, but kindly see the order passed by the government. No, Honorable Arnett Singh is there. I want to press Reliance. Manat, on no, certainly not. Entire judgment is before the Honorable Division Bench. But Arnett single judge, considering Abdul Badi's case and other, yes, and all the judgments have been considered, then rejected the application. Now, Mala considered. Today, we shall have lordship. As we for a moment, the school is a unaided school. Class 9 and 10. Then Mala kindly see what is the position of the law of unaided school is concerned. In 2005, the state government enacted law called West Bengal School Control of Expenditure Act 2005. Kindly see paragraph 6. Section 6. Section 2Q. No, I'm not saying that. Today, when the order was passed by the date of appointment order, we should have to grant approval today. Or order was passed by the Secretary. Initial appointment that when there was, but my lord, that their appointment was made in 1996. When the school was not No, what up? There is another legal bar disturbing us. School means section 2M. Then Malad kindly see unaided school. 2Q means a school, unaided school to which no financial assistance has been sanctioned by the state government. 9 and 10, no financial assistance. Then kindly see section 6. No unaided school shall be entitled to get a financial assistance from the state government. And this has not been challenged. If my lords direct us to grant approval from 1996, yes, no doubt of it. Unaided school up to only for 9 and 10. Una recognition. No, but the school, junior high school was I'm thinking whatever, but that. No, I'm saying, what a people. On the kindly section 20, giving overriding effect in 2005. The provisions of this act and the rules and orders shall effect notwithstanding anything contained contrary for the timing in force or any contract, custom, usage to the contrary. No, but I subject to whatever I have committed mistake. On to 1996, they wanted approval from 1996. Whether state government can be directed to grant approval from 1996 when there is no class 9 and 10. First question. In 1996, there was no 9 and 10. It may be the private arrangement, government was not responsible. Nobody asked them to open the school. They were asked to open the school 9 and 10 in 1999. Before counting the staff pattern of 9 and 10. 9 and 10 to be considered from 1st May 1999 and 10 from 1st May 2000 when 97 Act was there. Whether they are protected under section 10, that is to be considered by your lordship because of the interpretation given by the another division bench. কোথায় বলা কোথায় বলা 4 and 5. उधर 2005 से रहा Although this act is prospective, but 2005 Act and 97 Act was not protected the persons who are appointed before the 97 Act came into force. And judgment of Justice Mukherjee, with great respect to my of this court, because it is also division bench judgment, another judgment of justice division bench. If this is a good law, this is not a good law. One division bench. Justice Doctor judgment said that this is a good law, this is not a good law. And Justice Mukherjee, sitting in a division bench, said that this is the situation and they should be given approval. But Umadevi's case, that has been considered by Justice Doctor, division bench, that if any fresh appointment has been given approval, that means backdoor appointment, no advertisement, no selection process, no prior approval. If a single paper is produced before the lordships are included in the paper book, that there is a prior approval under Rule 28, power of the buying committee, certainly I have no case.
But I will add one thing. Only 5 minutes. But I will refer to your lordship, the government circular, page 99, wherein government circular my lordship said there is no concept of organizer teachers. Now kindly see the government circular at page 99 of 2005. At page 100, Roman 2, your lordship kindly has seen earlier. Roman 2, the appointments of only those organizer teachers and non-teaching staff of the newly upgraded high school, which was previously already permitted by the West Bengal School Service Commission to send up examinees for Madhyamik examination, has now upgraded from class 4 junior high school to class 10 shall be approved, who are serving at the school for the unrecognized units of class 9 and 10 at the time of dissolution of those units by the West Bengal Board of Secondary Education and have been continuously serving in the school. This is the government order. And secondly, my learned friend submitted with regard to Umadevi. Kindly see Supreme Court. What Supreme Court said. Supreme Court said, your lordship remembers, I am reading, your lordship remembers. Supreme Court said, Supreme Court, page 129. My learned friend said, in this case, Umadevi has not been followed. Supreme Court said that we, however, make it clear, state authorities. Yeah. Without being influenced with the orders as passed by the High Court. Yes. Yes. And also one line I am showing lordship, kindly, this is the last. In our opinion, there should be a considered, it appears to us that the Supreme Court is saying appellances working for such in this case shall be considered by the authorities in the light of the provision such and such. In our opinion, at the time of which consideration, it should be pleasure of the state authorities. You'll also consider, so my learned friend submissions, you'll also consider.
Just 1 second, but supplementary affidavit page 5. Supplementary affidavit page 5. There are undertaken given by the school authority, there is no organized staff.
We have
Supplementary affidavit, page 5. That's it. That's a good. Kindly see the supplementary affidavit, page 5. Headmaster of the school, appointment affidavit.
You have to rise at one, you have to sit. But Yes.
Any urgent mentioning of honorable code number 1?
May I have your lordship's kind leave to mention an urgent matter? Now, your lordship, in this matter, what has happened is on 7th October 2024, the learned single judge has passed an order directing that a CBI inquiry be conducted into the trespassing of the jute mill. After that, the matter was moved before the learned division bench during the vacations, and on 29th October, we have obtained a stay. Now, the stay is expiring on 28th of this month,
May I just
28th November,
may I just
Or 20.
28.
my lord, may I just intervene? My lord, possibly your lordship will not be able to take up the matter because your lordship has released this matter. So I just wanted to point that out before he.
Vacation bench will not.
Normally, he will not. It is operative. Go and mention the matter before the regular bench on Monday. The bench will be available on 18. Go and mention.
My lord, may I request, my lord, if the matter can appear on 18th in the list, my lord, if your
Go
lordship
and
can
mention
direct.
that. 28 is the long date. Even 10 days are there. The bench will take care of that. No.
Single bench data.
Not just yes. Next, any other
Single bench order এখানে
Item number 7.
I appear for the state respondents.
I'm for the appeal. That matter, Your Lordship yesterday heard the matter. The final relief or dismissed the writ petition, keeping pending.
Forgot. Have you got those line of judgments?
Touching that point itself.
Utkal University's judgment, if I correct.
Alert.
Jayaprakash University's or Utkal University's judgment is there.
On the same ratio or touching the same ratio, the Honorable Constitutional Bench of the Honorable Supreme Court just in the year 2024 held any application for modification or vacating without giving any opportunity to the other side cannot be, as well as if that is done, subject to the trial. In connection of that matter, a ratio has been decided, and Your Lordship, what have been uttered by Your Lordship, the same ratio Karnataka High Court Honorable Division mentioned. The word as expressed by Your Lordship yesterday, in the same tune it has been quoted. And the Honorable Supreme Court in respect of suit also quoting that application in the lieu of Order 7 Rule 11 application, unless that is heard, cannot go for trial. I have got all three judgments.
Give me the judgment of the
Karnataka.
Give that.
But the judgment, my lord, which has, my lord, brought in Your Lordship appeared for LIC in a matter that was reported in the NHL Karnataka.
Now, this is the judgment of the Honorable High Court Division Bench of Karnataka. Same ratio. Now, paragraph 42 and 43. The citation ILRA. Paragraph 42 and 43. দেখছি দাঁড়াও। হ্যাঁ, আমার কাছে আরেকটা কপি আছে। At page, I believe 12. Yes. 11 and 12. Paragraph 42, bottom portion of the page 11. Pagination is in the bottom. And paragraph 43 is the same tune as Your Lordship expressed yesterday. And Honorable Supreme Court also. Head note B, in respect of vacation or modification application, opportunity to be first page. Head note B, it connotes vis-a-vis paragraph 16, 35, 36. Reported. Head note B টা দেখো মডিফিকেশনের জন্য opportunity to be
No, this is not I really
not
There
touching
are
the point.
There are a direct point on that point. The direct judgments are there, which are very, very, very important. You have not seen that judgment.
No, yesterday I asked it, but
My fault that I can.
My fault also, I could not get it.
I could not get
Since I was searching till midnight, I could not get it.
That was my fault. Had it been in my mind, I have got the full judgments.
Any idea if Your Lordship can be?
Jayaprakash University or Utkal University judgment do you have? Or Utkal University, either of these? Just now I could recollect this judgment, 2006. SCC probably.
Giving me 15 or 20 minutes time.
Just find out. I think there is absolutely a direct judgment on this. Where is the judgment of Justice Bhaskar Bhatt?
রাখো না, আছে তো আমার কাছে। Kumar Srivastava, Ashok Khaitan, Bhagat Singh, Calcutta State Transport Corporation, Cotton Corporation, Housing Board, Government Bank, National Fund, Pepsi, একটা comment. না, এটা চলে।
Was correct. Singhania Developers was there.
জানেন?
Singhania Developer was there.
Yeah.
But cost title was different.
I also forgot. I do not remember the cause title. I go by the pagination or citation. Yes, Singhania is there.
This is 1, 2, 3, 4 page. এখান থেকে judgment শুরু হচ্ছে at the bottom. At the bottom, last line. Singhania. একদম Singhania Developers. We were representing the Singhania Developers.
Judgment call. List of it. My gosh.
Look at the paragraph 10, what we argued actually. This is what we argued.
Yes, column number 4. Column number 4.
No.
Paragraph 10.
One is the LIC was really asking for a review of an order under the guise of a clarification and or modification.
Yes.
And or variation which is not permissible.
Yes.
This was the first point which was argued by us.
Yes. Yes. Well, ভুলে গেছি।
Only my lord, one distinguishing. May I try to assist your lordship on one score, my lord. One distinguishing feature, in my humble understanding, is, my lord, here, my lord, there was nothing on merits. My lord, we have made certain submission. He had come to the court saying, I have been redesignated as technical assistant group 2. That is not reflected in my service book. And the university is not giving promotions to me. Lord, we have submitted to the court that yes, we have by syndicate resolution dated such and such, we have redesignated him as technical assistant group 2. Lord, we failed to assist the court with the fact that there was a subsequent resolution of the syndicate. There was nothing on merits, my lord. When there is nothing on merits, there is no adjudication on merits. My lord, my lord, I am not, my lord, I am not. Absolutely, my lord. My lord, my lords will, my lord, that my lord, that the my lord will send it back. Nevertheless, my lord will kindly secure my interest to the effect, to the no, my lord will kindly see. Look, today, my lord, no, my lord will kindly come to there is no interim order. If my lord, my humble reading of this, my lord, there was a submission. On the basis of a submission, something was recorded. My lord, no, my lord will appreciate, my lord. My lord, I know, my lord, what falls from your lordship can be written on these stones, my lord. My lord will kindly give me an opportunity to, my lord will remand it back. But my lord will kindly, my lord, not held me liable for the my not knowing a fact. This, my lord, the my lord. Me, I, my lord, I'm, my lord, no, I do not join issues on that, my lord. I do not join issues on, but my lord will kindly see.
Exchange of evidence.
My lord will. Lordship wants the on recalling application, my lord.
Yes. In the meantime, I shall also search that those cost title judgments your lordship has given me.
Item number 9.
In the weekend, I shall.
Grateful, my lord.
Much obliged.
Item number 9. Happens to be
I'm the appellant, man.
Well, I am for the state.
But before proceeding with the appeal, matter, there's a so I'm saying extremely sorry, man. But what has happened in this matter, my lord?
The board is the necessary party here.
Board. No, no. But board is the necessary parties. Primary board is the necessary party, but
There is an order which 7.
office service করেছেন main
The impugned order, my lord. 7th. My lord, my lord. My lord, this is at page 150, my lord. 50, my lord, 50. Not 150, my lord, just 50. It's a simple withdrawal order, my lord.
I am led by Mr. Sudeep Ghosh Chaudhary. He is engaged in another court. Kindly allow short passover. He's he is on his leg at court number 18. Lordship. Lordship. Lordship, same.
To 33 those matters one study analysis Mrs. Maiti is leading in some matters we are the appellant.
My lord, in
Yes.
Your Lordship wanted me to argue today.
my lord, kindly recall us, my lord. Mr. Ujjwal Rai was leading me, my lord, in this matter. For some of the appellants, my lord, this is pertaining to equal pay for equal work. My lord.
My lord, the constitution today.
1996
বইগুলো
my
পরপর
lord.
নিয়ে ওদিকে নিয়ে ওদিকে সরিয়ে ওগুলো নিয়ে আন মামলা করতে পারবো না এইভাবে বইগুলো নিয়ে আন থাক থাক Now, my lord, your Lordship, my lord, here, my lord, I am representing, my lord, 4 cases. 14, sorry, 14, call ball. 14, 18, 19, and 28. Now, my lord, before I open the cases, my lord, there is a factual difference in this case with the other 3 cases I am appearing. The others I do not know. What has happened in this case, this Rotikanto Das, here, my lord, the DPI has held that that the incumbent is entitled to equal pay for equal work, but since the government was not a party to the arrangement and the college is allowing him to continue even after 6 months, initially he was appointed, so they will bear the expenses and they will. Yes, but in this. In this case, the factual difference is slightly different here. In the first case, if your lordship takes, my lord, this, the impugned order. Yes, my lordship, kindly have a look to page 68 once. Once, my lord, I just 68 once. 68, this is not there. Lordship.
I beg to appear on behalf of the Milord, writ petitioner appellant to raise Milord second item, that is Milord 15.
No, my lord, lordship, kindly, my lord, the page 87, my lordship, kindly, or 87 or 74, my lord, two marking, two dates, two numbering is there. The penultimate paragraph of this impugned order in the writ petition. 70, the DPI. Yes, ma'am. That is page 87 or 74. I don't know. This is, I think, 74 should be there. Uh, 21st March 2018. 21st March 2018. Right, It starts. Yes, lordship. Lordship. No, 31st March. Yes, 20. It is Malad. Maladi 68. It is written 21st March 18. Yes. And Maladi. No, that is true. That is true. Yes. Now, lordship, kindly takes Malad page 74, penultimate paragraph. Considering all the probabilities in this regard, it is of the view that the college authority shall bear all the liability. No, my lord, lordship, kindly.
One matter.
Yes.
One matter. Case number to mention for us.
Here, my lord, the difference is in this case, my lord, it holds following the principle, college authority shall bear all the liabilities. This is not there in other orders of the DPI. Only difference, factual difference is this in this case. And in other cases, it holds that no, they are not entitled. But that is there. I cannot improve upon this. Now, that's why I thought I should assist your lordship properly. So this difference is there in the other impugned orders, subject to correction. But in now, my lord, this I just kindly have a look to, my lord, the opposition of the state respondents in this case. Page. Yes. No, I cannot. Yes. Yes. No more in this case was very well, man. Very well. You are enter. Lordship. Yes, lordship is correct. My lord, I would be failing in my duty. পেজটা দেখা না 87 91 পেজটা দেখা বাস্তবে তো বলে কেন বাড়িতে আসতে পারে না Now, my lord, now, my lord, here, now, my lord, here, my lord, there is something I have to say. My lord, lordship kindly sees my opposition, my lord. My lord, it is in a different way. According to the government, they are not entitled to. If they are entitled to, then that has to be redressed by the college authority because it is they who allowed. Now, my lordship kindly, I am showing my affidavit. Nobody can improve the case by filing affidavit otherwise. Lordship, I know that principle. But here, if I had not pointed out, then there would have been some difficulty in dealing with other cases. So I thought this difference I should point out at the threshold. That's why to assist your lordship, I have pointed it out. Now, my lord. 87 কোথায়? Now, my lord, this here, my lord, lordship kindly sees page 89. Kindly have a look. Page 89 of this. Yes. In all other cases, no, my lord, this is yes, right-hand side number, my lord, 89. This is 31st July 2018 order of the DPI in another matter. It starts, but the operative part, page 89. Penultimate paragraph, but lordship kindly sees here what it is written. I am of the opinion that the benefits of memorandum so-and-so dated so-and-so issued by the finance department cannot be extended to the present petitioner since the undersigned cannot recognize the petitioner's engagement towards approval on the above mentioned two major issues. The undersigned is unable to decide the petitioner's entitlement to equal pay for equal work. Unable to decide the applicability of entitlement to equal pay for equal work. Now, my lord, here, yes, কোন পেজটা বল? যোগাযোগ ফলো করতে পারিস না নাকি? Signature, my lord, yes, at the bottom, my lord, yes, some M. Mojumdar or some M. Mojumdar, but he is, my lord, the communicating authority. This is the memo is forwarded for information to such and such. There is nothing, my lord. Now, my lord, I just want to, but the records will speak, not the council. Now, my lord, here, my lord, this your lordship knows that this our equal pay equal is flowing from Article 39D, Directive Principle State Policy. Now, it is not a fundamental right; it is a constitutional goal. So that equal pay. Now, well, I'll cite judgments, but here the lordship can decide on this basis also. Well, leaving aside the DI, what the DPI has said, your lordship can decide that. No, now, my lord, yes, my lord, the first submission is, my lord, that I was just about to advance. The first thing, my lord, my first point. Yes, that's my first submission. And I'll be citing a judgment. Yes, not a constitutional right. It's a constitutional goal. I am not saying it is Supreme Court has said that. They cite judgment 2011, বাড়িতে আসিস না কেউ, কেউ আসিস না তোরা। 2011 judgment আছে। May I cite one judgment? 2011, volume 11, Supreme Court cases 122. Yes, yeah, I'll come up to 2022. Where 24, I'll also come. Now, my lord, this judgment, Lordship, kindly have a look, my lord. I just 2 paragraphs within.
Lord, your lordships are not audible to me, my lord. Still, you know, two submission I shall make before your lordship. Your lordship already, my lord, heard me yesterday, but only prayer I shall make before your lordship.
Madam, আমাকে একটু বলতে দিন।
Very well. Sorry.
Allow me.
Sorry.
Well, the 2011, volume 11, SCC 122, paragraph 22 and 23. Well, it starts, it is the paragraph 22 I place. It is the duty of an employee seeking parity of pay under Article 39D of the Constitution of India to prove and establish that he had been discriminated against, as the question of parity has to be decided on consideration of various facts and statutory rules, etc. The doctrine of equal pay for equal work as enshrined under Article 39D, read with Article 14, cannot be applied. Now, my lord, this, my lord, equality, yes, my lord, but the at 3. Then, my lord, not on Monday, my lord. I have some difficulties on Monday. Let it be on Tuesday, my lord. And in that case, my lord, Wednesday kindly, my lord. Monday I have some difficulty.
Let it appear on Monday before your lordship.
Lordship, I'm grateful.
My lord, there is another matters also. 14 to 21 is same man identified. Monday.
Sure.
We have not, and I'm for the state respondent, but we have. हमने mentioned that. We have not mentioned. Five.
Lordship, I am for the petitioner led by Mr. Sudeep Ghosh Chaudhary. It is for correction in page number 4, paragraph number 2. 4. Paragraph number 2, in line number 4, DI is written as Jhargram. It ought to be Purbo Mednipur. Yes.
এইটাই তো
Appearing for the state respondent led by Mr. Chaudhary.
But I'm for the read petitioner respondent. Grateful.
3 and 4. 3. There are two appeals. 2 and 3. 2 and 3.
Grateful man. No. Grateful.
Item number 6, review.
Item number 3.
But for the applicant, my lord, my application, my lord, for review. But the only ground, my lord, is that this writ petition, my lord, was filed against the order of the learned tribunal, rejecting my prayer for compassionate appointment on the ground that my father was a work charged employee. And lordships are also pleased to dismiss my writ petition, my lord, only on that ground itself, since my father was a work charged employee, I cannot get the benefit. But my lord, mistakenly, my lord, this has been a mistake. My lord, the proper facts were not placed before your lordship that my mother, my lord, gets the pension. My father cannot be an work charged employee. I have, my lord, annexed, my lord, my father's, my lord, this. Yes. But annexed, my lord, with the memorandum of review, memo to work out. It is the order dated 17th of June 2022.
Not gotten copy of memo. Fine. Memo copy mine.
Right.
Okay, যেটা বলা হয়
Minor. Yes, ma'am. My lord, my learned friend, my lord, who has been filing, he has get this brief, my lord, on transfer. ওর নাম কি তোমার? My lord, Diptendu Kumar Pal.
We are not there and they are being asked. No. All that. That is what.
My lord, AIA 99. আমার দাও।
কত নাম্বারটা বলো? CPN 119 2022. Yeah.
I think the first paragraph is
CN
will convey a very, very thoughtful intention.
1198. Of 22. কেন এক হচ্ছে 21 বলে দাও বলে দাও 21
Well, there is an exception, my lord. When an appeal or special petition dismissed, except in rare cases, where error of law or fact is apparent on the face of the report.
You wanted that the argument was not advanced properly. I wanted to argue it proper manner. That is the application there.
Alright, yes, ma'am. The first paragraph is there. But only my prayer before your lordship.
Sitting on a ground of delay anyhow, so that at least your responsibility will not be there.
May I just request, my lord, can we just get the, my lord, liberty from this honorable court so that we can approach before the learned tribunal to this effect? Because this has been, my lord, this has been, my lord, ruining my life, my lord. This is what. Because it is a strong fact that my father is a regular employee. Yes, my request, my lord, if only because I have been making this request, my lord, it is there. It is completely standing in the way. My lord, since only, my lord, it is a case of compassion upon, otherwise I would not have requested your lordship. My lord, I was just praying, my lord, if I could just agitate this point before the learned tribunal once. কতদিনের ডিলে তো লেখনি গো দিন কত Ashwin. Only one because I was praying for this compassion appointment. My lord.
I'm for the petitioner, my lord. My lord.
Well, I am appearing for the alleged contempt now.
Lordships, I beg to appear for the petitioners, your lordships.
No, my lord. Well, pursuant to my lord's direction, my lord, the parta has been annulled. Now, my lord, I have received the report. Now, my lord, the part for the alleged contempt. My lord, matter was, my lord, the
Lordships, kindly have a look at your lordships.
the land vested. Now, subsequently divested. So, my lord, the order was passed for correction of record of rights. Since the parta has been, my lord, issued, so annulment parta proceeding was pending before the concerned SDO. Yes. It is just okay. Now, only one thing, that the delayed compliance, but only one thing, parta has been issued. Kindly see the last page. The concerned SDO annul the parta, but says since the parta will file an application being CAN number 1 of 2024 before my lords, so that reflection will be affected after disposal of this. And the BLNL that is the delay this admittedly there is the delay
My lord, may I find you one can application changes to annual basis? So I don't know. So I don't know but my right was kindly yes, yes, my lord, it's kindly allow me. My lord, I am not but during but consequence but if my right was but practically my right, yes, my right. My lord, kindly allow me for a moment. My lord, kindly allow me. My lord, we are in dark. My lord, we are in dark. My lord, first time. My lord, kindly allow me for a moment. My lord, kindly allow me for a moment. My lord, I know that I have a not a independent right to participate in contempt application. But what right my affected? But the first time I came to Lord, my lord, that is the regarding cancellation of my parta. My, sir, then you go with your right eye. Yes, my lord, but yes, but first I I I will challenge this order, but first time I came to the know one. Neither a tribunal application nor a high court's application, I was not included as a party. First time I know this. Regarding service of this, my cancellations of part. Before that, my lord, I was neither a party or.
Yes, yes. Malad, kindly, no, no, Malad, kindly see the previous page. Malad, the such and such, Malad, the RNL, BL and LRO Khejuri 1 is directed to record accordingly. Thereafter, Malad, since the can was filed, Malad, the no, Malad, now, Malad, within, Malad, since my lord, Malad, dispose of this can, Malad, within 7 days, we shall rectify this record. Next also same, Malad.
Lordships, on humble prayer, your lordships, the copy of the report submitted by the state may kindly be given to us, your lordships. Copy of the report.
Yes, I have received.
My lords.
Same. Yes, yes. Same app. Same app. Nine, Malad, my lord, order has been complied with, Malad, the matter.
I am the petitioner, my lord, but I am filing the affidavit in service, my lord.
Malad, compliance.
Not compliance, my lord.
Malad, the my lord's direction was for consider the representation that we have, Malad, initiated a miss case, and Malad, decided that representation and passed an order. That order was against them.
Not compliance, sir.
No. Order 2020. Malad, final order was 13.
Yes, my lord.
No. 13 July 2022. Malad, order sheet, Malad, the order being Malad, 26 July. Order being number 3. Final order. 13 July, the next is the final. Next, another order is there. 26 July. My lord's order passed on
8/6/22, my lord. Not comply within time, my lord. 8/6/22, my lord, this was passed an order. Yes, my lord. Thereafter, he has taken hearing, my lord, and then this order has just now I received from my learned friends, my lord. Not complied to me, my lord. And
Malad, they file Hajira, Malad. Yes.
my lord, contempt order, my lord, this order just I received, my lord. I don't know he was passed this order, my lord. But the order
I am appearing on behalf of the petitioner, my lord. Affidavit in reply, my lord, kept on record. my lord.
My lord, I'm praying for not today, my lord. My lord, the council representing the
Yes, my lord. My lord, kindly.
my lord, my lord, actually the counsel for the respondent is out of station and he left yesterday afternoon only. No, my lord. After he left, my lord, he is also.
And my lord, this is a long pending matter, my lord.
My
It's
lord,
a WPC 2000. Yes, my lord, very. Well, affidavit of reply, my lord, kept on. My lord, it will be kind and sorry, my lord, it will be kind and grateful.